Great. Good afternoon, everyone. My name is Steve Raucher. I'm here with my good friend Mike Sohigian, and we're pleased to be giving you our annual insurance update, looking at important insurance cases from 2021. Before we get started, I did want to take care of a few housekeeping matters. You'll see the housekeeping matters are in the chat of the Zoom call, but I wanted to call particular attention to the information about MCLE certificates. You'll receive your MCLE certificate shortly after this program, and your certificate will also be stored in the BHBA Plus members only community on the BHBA website, in case you need access to it there. And we would ask that you please take a moment to complete the survey that's included with your certificate if you like this program.
If you don't like it, please don't fill it out.
I want to first give a special shout out to Mike this year, who is actually not calling in from the Millennium Falcon, but he is calling in from the Glendale courthouse because he's in the middle of a lengthy bench trial. And so he's actually calling from the courthouse today because right after this program, he has to go back into trial. So that's kind of above and beyond the call of duty, and I want to thank him for that. In terms of questions about anything that's going on during this program, what I would encourage people to do is use the Q&A feature in Zoom at the bottom of your Zoom page, and we will do our best to look at the questions that are coming in during the course of the program, and the person who's not talking will look at those and depending on time, perhaps try to address those in the, at the relevant time when we're talking about particular cases. In the event we're running out of time or we want to make sure we get to other things and we have time at the end, we may go back to those questions and try to answer whatever we don't cover. The chat function is also open in case you want to make a comment. But if you want to address a question to us, the best way to do it is to use the Q&A feature. I'm going to start off the substance of the program. I'm going to put up our PowerPoint to get that started. And we're going to begin the discussion with important cases about first-party policies. And part of the reason we're starting with that is because some of the, I think, most important and interesting cases from 2021 have to do with COVID-19 business interruption insurance, and that's where we're going to start. So with respect to COVID-19 coverage, it's interesting, 2 years ago on April 6th, I guess 2 years ago in one day, April 6, 2020, at Mike's behest when he was the president of the BHBA and we were all just getting into the pandemic and the shutdowns, I participated in a program where we talked about whether there was going to be coverage for business interruption losses due to the pandemic. And at that time, from a policyholder's lawyer perspective, it was sort of a time of great hope and optimism. And that's reflected by Captain Kirk on the left side of your screen. But as things developed in this area of COVID-19 coverage, by the time we got to the end of last year, we were to the right side of your screen as far as how lawyers and policyholders were doing in terms of succeeding in getting COVID-19 coverage, which is to say, not very well at all. And immediately after the pandemic and people started filing these COVID-19 claims, it pretty quickly became apparent that the trial courts, at least, were pretty hostile to the claims. And they began to be thrown out at the pleading stage. They weren't even getting to summary judgment, much less trial. But in terms of appellate authority, and in particular in terms of appellate authority applying California law, we really didn't have anything until mid to late last year. And the first case first appellate case that came down applying California law was actually from the Ninth Circuit. That's this Mud Pie versus Travelers case. And that was sort of the first nail in the coffin. And then there was a second nail that we'll get to in a minute that happened not too long after Mud Pie. But in Mud Pie, you had the insured who operated a children's store in San Francisco, which had ceased operations following the issuance of a local shelter-in-place order. Mud Pie actually filed a class action against Travelers after its business interruption claim was denied. Now, the key policy language that it was in the Travelers policy and is pretty typical for all first-party property insurance and business interruption claims is the following. Travelers will pay for the actual loss of business income that the insured sustains due to the necessary suspension of Mud Pie's operations during the period of restoration. And the suspension must be caused by direct physical loss or damage to property at the described premises. And it's that language, direct physical loss of or damage to property, that is the key language regarding coverage in all of these cases. Travelers contended that Mud Pie's losses were not the result of direct physical loss. They also contended that there was a virus exclusion which barred coverage. Let me just pause there to say, even back in April of 2020, my prognostication was that for first-party policies that had virus exclusions, there was not going to be a way to get around that exclusion. And that certainly has proved to be the case. But the more interesting cases are cases in which there was no virus exclusion. And even though there was a virus exclusion, the Ninth Circuit in this case also determined that there had been no direct physical loss or damage to property with respect to Mud Pie. Before we got to the pandemic, there had been some cases, not in California, but from other places around the country, which had held that it was not necessary that there be structural alteration in order for there to have been direct physical loss. For example, there was a case in which there had been an ammonia spill in a factory, which rendered the factory unusable for a period of time, not because of any physical alteration to property within the factory, but simply because of the ammonia spill. And that case found that there had been the potential, or that there was coverage. And there had been a somewhat similar case out of New Hampshire Supreme Court in 2015, finding that an allegation of cat urine odor in a condominium constituted direct physical loss of or damage to property, again, even though there had been no physical alteration of property. So there was some reason to think in March of 2020 that the courts might find that this just the mere presence of coronavirus could be enough. But that has not turned out to be the case. And in Mud Pie, the district court granted the motion to dismiss. And the Ninth Circuit, citing a case called Mri Healthcare versus State Farm, found that for the loss to be covered, there must be a distinct, demonstrable physical alteration of the property. In the MRI case, the insured's MRI machine had to be shut down during a time when there were roof repairs going on at the property. And they then had significant trouble restarting the machine. In fact, they couldn't get it restarted for several months. And so they made a claim under their property policy, but the court in that case found that, well, there was no physical damage to the MRI machine. It's not like the roof repairs led to the machine being damaged, and so that there was no loss in that case. And
Steve, that was a claim. I'm sorry, MRI was a claim for business interruption benefits?
Yes, it was. I'm sorry if I was unclear about that. Yes, it was. So the court rejected in Mud Pie the argument that there had been actual damage was not required. The argument that the insured was making is, well, you don't have to have damage to the property. It just needs to be no longer suited for its intended purpose, but the court found that direct physical loss is not synonymous with loss of use. And the court also pointed out that there were other provisions in the property that were consistent with requiring actual physical alteration. For example, I read the definition of what's covered, and it provides that there's coverage only during the quote unquote period of restoration. And so the fact that there's this period of restoration temporal requirement suggests, well, there had to be something to be restored, meaning some kind of physical damage. As I mentioned, the court also held that the virus exclusion applied. That was sort of a no-brainer. MudPie argued that its losses were caused by the stay-at-home orders rather than the virus, but the court found that it was the virus that was in fact the efficient proximate cause of the loss, so the virus exclusion applied. It was the virus that set the other causes in motion. So that brings us to California Appellate Authority in the Inns by the Sea case, which was decided in November of 2021. And somewhat similar fact pattern, the Inns plaintiffs operated 4 lodging facilities in Monterey and San Mateo counties that were affected by stay-at-home orders. Trial court sustained the demur. So again, the case was thrown out at the pleading stage. And the Court of Appeal framed the issue as one of first impression. Does a commercial property insurance policy provide coverage for a business's lost income due to the COVID-19 pandemic? And the answer was just no, it doesn't. Same policy language. The suspension must be caused by direct physical loss of or damage to property. The plaintiff in Inns argued a little bit differently than MudPie had, arguing that the physical presence of COVID-19 transformed the property from a safe condition to a dangerous one. But again, the court found that the business interruption losses were caused by the shutdown orders, not by any physical damage to the property.
Interesting, because MudPie argued that it was the shutdown orders that caused the business interruption because they had to get around the virus exclusion. I presume there was no virus exclusion in the Inns case, the policy for Inns. Is that right?
Yeah, that's right. That's right. Yeah, the court reasoned that whether or not the plaintiff had to disinfect the property, it would have still been required to suspend its operations in light of the government orders. And again, that there was no direct physical loss. There was an additional coverage that was discussed in the Inns case that was not discussed in MudPie as well. And it's one that back in 2020, I thought had the real potential to provide coverage, and that's the civil authority coverage. Civil authority coverage applies to loss of business income sustained because a civil authority prohibits access to the described premises due to direct physical loss of or damage to property other than at the described premises. So for example, if there's a fire in the property next door to you and the civil authorities say it's too dangerous, you can't go into your property, and you suffer business losses as a result of that, then that's something that can be covered under the civil authority coverage. And the way I looked at it was, well, maybe, a particular restaurant that had to shut down because of a shutdown order didn't have any evidence that there was virus in its particular location. Nobody had gotten sick at its particular location or what have you. It was just caught up in the shutdown orders. But that certainly, somewhere within the geographic area covered by the civil authority coverage, there were places where clearly there had been virus, whether it be a nursing home or, or what have you. Which resulted in the shutdown orders. But the Court of Appeal did not buy that. Again, they felt that because the orders were really issued for preventative reasons rather than direct physical loss of or damage to any particular property, that there was no civil authority coverage. There were a number of other cases that were pending in various courts of appeal, both federal and state, when the Inns case came out, and the plaintiffs in those cases asked the courts to refrain from issuing a ruling until after it was known whether the Inns Court was really going to be the final word. And within the past month, I think, it turned out that yes, it is the final word, because although there was a petition for review that was filed, it was not granted by the California Supreme Court. So that leads to the question of, well, with all that, what's left, if anything, in terms of the potential for COVID-19 coverage? The way that the pleadings were framed in Mud Pie and Inns, there were not actually allegations that the virus in fact caused property damage by physically altering surfaces at the covered property. And the Ninth Circuit actually noted in Mud Pie that had Mud Pie alleged that, they might have survived or would have survived the pleading stage. So there may be a very narrow category of cases where there could be still some potential for coverage, not business interruption losses so much. But as an example, there was a recent district court federal decision that came down following Inns, in which the Los Angeles Lakers are the plaintiff. And they alleged, in addition to business interruption, they alleged that the virus's mere presence on surfaces at Staples Center changed their chemical and physical properties that required cleansing or replacement, and that they expended a lot of money at Staples Center as a result of that. And the district court declined to dismiss that claim, although it did dismiss the business interruption claims under the Inns case. So not every business is going to have very much in the way of those kinds of losses, but a place like Staples Center, you could imagine that the cost of doing all that is really quite substantial. So the federal insurance in that case still is facing some liability, but that's really the only thing left in terms of first party coverage, I would say, for COVID-19. Business interruption claims, including based on civil authority, are really gone. So with that said, I'm going to turn the mic over to Mike to talk about a few other first party cases.
Well, we are at 20 till. Maybe we should go first to Pinto because of the bad faith cases. This was a case that really made law. Guastello is a fairly standard case. You can see it's a ruin, and that's because Guastello was a property owner who sued for a retaining wall that collapsed, This is an issue that comes up very commonly. The retaining wall collapsed in 2010. The homeowner had bought the property in 2006. The subcontractor completed its work in 2003, and the policy expired in 2004. So AIG rejected tender after the homeowner sued POS, who was the sub, because the property damage didn't occur until 2010 after the policy had expired. And POS then defaulted. The homeowner took POS's default and sued AIG under insurance code 11580. Now, what's interesting about this case actually is that 11580 includes the ability for the judgment creditor to sue the carrier for bad faith. So without a direct assignment, which is typically how a third-party claimant will get the defendant's bad faith claim, but under 11580, there's statutory authority for the plaintiff, the judgment creditor, to sue for bad faith. So the question has to do with the distinction between claims made and occurrence-based coverage. Most of these policies are occurrence-based. Claims made it comes up in professional negligence cases. If Steve or I were ever to get sued, perish the thought. Those policies are claims made often. But occurrence-based means when the damage was suffered. And it's not the commission of the wrongful act, it's when the damage is suffered. So POS finished its work. The homeowner had hired an expert who testified in support of the default judgment, that there were latent defects in Paz's work that then manifested subsequently to cause the damage. So that's why they call it continuous or progressive damage. And this case came to the Court of Appeal on a summary judgment that had been granted for the carrier, for AIG, and the Court of Appeal reversed because it found that the timing of the damage was a triable issue of fact that AIG had not proved took place outside of the coverage period. Fairly straightforward case. To me, I've seen a lot of these cases. The most interesting lesson that I learned from it was that you can sue for bad faith under 11580. You don't need an assignment. So, and there was a bad faith claim, and the court said all three of the homeowner's claims, bad faith, declaratory relief, and enforcement of the judgment, hung on when the damage occurred. Okay, next slide, please.
Okay, Mike, why don't we do the next two first party cases and then we'll jump to Pinto and talk about bad faith.
Great. All right, so this is a painting by Hieronymus Bosch called The Conjurer, and what he is doing is playing a shell game. And that's why I chose it, because Wexler versus California Fair Plan Association also was a bad faith claim, but it was for first party coverage under the Fair Plan, which you know is kind of the assigned risk program for fire insurance. Wexler lived with her parents, and they all three made claims on their policy for damage. I think it was smoke damage related to one of the big wildfires. And Wexler, the policy that her parents had coverage for a family member who resides with you. And the lawsuit, Wexler's claim was that Fair Plan had not properly or maybe properly adjusted or maybe adjusted at all her claim. They had simply rejected it. So as you can see, the policy provided coverage for personal property of family members living in the home, but it didn't identify Wexler as a named insured or a loss payee, and it had this language: this policy does not provide coverage to any person or entity not named here. So the Court of Appeal, it was a split decision, 2-1. The majority concluded that the daughter was not a party to the policy. She was not a signatory, she was not an additional insured, and she was not a third party beneficiary. And instead of looking at third party beneficiary, if you read the case, it's interesting. They not a signatory is obviously, she didn't sign it. And the language that says somebody who's not named is not covered meant that she was clearly not a named insured or additional insured. So the real question was she a third party beneficiary? And instead of analyzing that, in my view anyway, the Court of Appeal simply said, well, look, if she were not covered, that would encourage moral hazard. And clearly the parents are not gambling with their own daughter's property. And it was kind of convoluted, frankly, because I think the key is that the question was, did the parents have an insurable interest in their daughter's property? Yeah, here we go. So if you look at Insurance Code section 281, that defines an insurable interest. And essentially what it means is that an insurable interest exists, or an insured has an insurable interest if loss or damage to the property would directly damnify that person. And damnify basically means harm them in some way. So if the property, if it's the daughter's property, how does it damnify the parents if she loses it? And now we can go to the next page. Thank you, Steve. So the dissent said, look, this coverage for a resident, a family member, is illusory because the parents paid a premium. If they sued, they couldn't pursue the claim because the dissenter directly addressed this insurable interest issue and said, look, because loss to her property doesn't directly damnify the parents, so they don't have an insurable interest, and the property's owner, according to what the majority ruled, cannot sue herself because she's not a named insured. And so the question then is, would Fair Plan deny, or would Fair Plan's name insured's claim for property damage to resident family members be covered, right? So could the parents actually have done that? The Court of Appeal assumed, the majority assumed that they could, and the dissenter predicted that they could not. And I have the feeling that the answer is probably within the procedural history of the case itself, because the parents and the daughter dismissed their claims at the trial level in order for the daughter to be able to appeal. So that tells me that the parents probably got their claim denied too, but I don't know that. So that's really sort of the open question, is the majority's ruling depended on this assumption that, well, look, the parents paid a premium, they would get benefits if they sued for the loss to the resident family member's property. But I don't know if that's true, and it's not answered in the case. So I don't know, maybe stay tuned.
Okay, let me talk about one other first party case. There were a lot of first party cases last year before we jump to bad faith, to make sure that we have adequate time to talk about those cases, which are probably the other most important type series of cases that were decided last year. The first party case, there's a Supreme Court case on life insurance notice issues, which we'll talk about if we have time. But a little bit more interesting case, I think, was this Chu versus Old Republic home protection company case that came out of the Court of Appeal that has to do with home protection contracts. And the question was whether those actually constitute insurance at all. And therefore, whether if there was a breach of one, whether the plaintiff can state a claim for bad faith. And what happened here was that the plaintiffs purchased a home protection plan, which many of us probably have purchased, particularly when we first bought our homes, for a condominium by which Old Republic agreed to provide service for covered systems and appliances within the condominium that are reported as malfunctioning. And the contractor selected by Old Republic failed to properly repair the air conditioning system. And so the plaintiff sued Old Republic for breach of contract and bad faith. The trial court sustained a demur to the bad faith claim, and the plaintiffs appealed. The Court of Appeal looked at the legislative history behind the regulation of these home protection contracts and noted that in 1978, there had been an opinion from the California Attorney General that opined that home protection contracts were indeed a form of insurance. But the legislature, in response to that, amended the insurance code, and they specifically declined to treat home protection contracts as insurance contracts. They did specify that there were certain provisions of the insurance code that applied to home protection contracts, but not all of the provisions did. And so from the legislative history, the Court of Appeal made that determination. If you stop and think about it, it's kind of remarkable that it took over 40 years for this issue to be resolved. But I get the sense that these are usually small dollar claims, and so perhaps that's part of what explains it. Interestingly, in terms of thinking about what is insurance for, the court went on from the legislative history analysis and did a public policy analysis as to whether, okay, even putting aside what we think the legislative history shows and the legislative intent, would it make sense to treat home protection contracts as insurance? And they found for three policy reasons, that it would not make sense to do that. First, the buyers and sellers of residential property don't lack meaningful bargaining power. That was one of the considerations. Second, that home protection companies don't undertake the same quasi-fiduciary responsibilities that insurers do. Insurers actually have a responsibility to defend homeowners or settle claims against homeowners. Home protection contract companies do not have that. And they also don't, there's not the requirement of a quote calamity or catastrophe in the same way that you would normally expect under a first party policy. It just is that an appliance stopped functioning. That doesn't necessarily have to be because there was a fire or an earthquake or anything like that. And finally, they found that the financial requirements that would be imposed on home protection companies if they were to be treated as insurers would likely drive them out of business. So for those reasons, it rejected the plaintiff's attempt to state a claim for bad faith. Okay, so I'm now going to skip forward to the Pinto case, and Mike will talk about bad faith cases, and then we'll jump around a little bit to the other cases as time permits that we think were most interesting and important.
So Pinto is very important. Now here, this is a judge shrugging. And the reason that I chose that, as you can see, perfectly licensed piece of imagery was that Pinto's a bad faith case in which a $10 million judgment was reversed. And the reason that it was reversed, it's a bad faith failure to settle case. And the reason that it was reversed is that the trial court approved a special verdict form that was based on, next slide, please, that was based on a Casey instruction, Casey 2334, I believe. It's on the following slide, I believe, that lays out the 2234 that lays out 3 elements of bad faith failure to settle. And you see them right there. Insured was sued for a covered claim. Carrier failed to accept a reasonable demand within policy limits. And there was a judgment in excess of policy limits. So, excuse me. So the trial court did basically what Casey told her to do. The judgment went against the carrier for, as you can see, almost $10 million. The Court of Appeal reversed and essentially added an element to bad faith failure to settle. So the question was whether in the context of a third-party insurance claim, failing to accept a reasonable settlement offer constitutes bad faith per se. And what the Court of Appeal held was that the plaintiff in a bad faith failure to settle case must also prove that the insurer, in failing to accept this reasonable settlement offer, acted unreasonably. So just failing to accept the settlement offer does not necessarily constitute bad faith. The critical issue is the basis for the decision to reject, right? So this was a difficult case, as you can imagine, a $10 million judgment. It was a case that involved substantial damages, a group of, I assume, young people partying at Lake Havasu, driving home somewhere in Southern California, and they're driving in a pickup truck. It's not really clear who's driving, but the signs point to a young woman whose license was suspended and had previous DUIs. The pickup truck goes off the road, it flips, and Pinto was rendered quadriplegic. It was a case in which there was a settlement demand made within policy limits. There was the insurance company was having difficulty working with the person that appeared to be the driver who was not their insured. So it offered, yes, exactly. These are the facts here. The carrier offered policy limits on the 14th day, one day before the deadline, but it wasn't able to satisfy all the conditions having to do with course and scope, availability of additional insurance, mostly because the driver was not the presumed driver was not super cooperative, and they weren't able to get back the information, the carrier that is, wasn't able to get back the information that was requested relating to her. So the demand expired, and then they settled the underlying claim for the equivalent of a $10 million judgment, a payment of $65,000 because it turned out the driver did have $15,000 of coverage that was added to the insured driver's $50,000, and an assignment of rights against farmers to sue for bad faith. So they tried that case. There was a jury trial, the bad faith claim, the assigned bad faith claim, and the jury awarded judgment to the insured. And farmers appealed, and their appeal was based on the fact that they had behaved reasonably, they argued, in failing to accept the settlement demand within the time limit. There was actually a finding by the jury. The jury did not find that the carrier acted unreasonably, and there was a finding that the failure of this this third party, the uninsured person, created difficulties for them. So that means there's now a fourth element for bad faith failure to settle, and that is not just that the carrier failed to accept a reasonable settlement offer within policy limits, but that failure was itself unreasonable. Then the question is, how do you remedy that, right? You've got a $10 million verdict, and the Court of Appeal chose to reverse, which was pretty extreme response, it seems to me. But the Court of Appeal said, look, it's the defendant's fault. It's the plaintiff's fault. It says court blamed defendant for the defective verdict, but that's not right. That's my mistake. It was the plaintiff's fault. The court blamed the plaintiff for the defective verdict because the plaintiff not only failed to propose an appropriate verdict. Now, how would the plaintiff have known what an appropriate verdict would be? 2234 has the elements right there, right? I mean, that's Casey. But he also vigorously opposed farmers' attempts to clarify the erroneous verdict. So the court decided the proper remedy is to vacate the judgment and enter a new judgment for farmers. Now, that is a very hard lesson. If it is a lesson, it seems to me it's kind of a change in the law after based from the law that the case was tried on. But it's a very hard lesson for this plaintiff. But it is a lesson that I'm sure plaintiffs will have learned going forward. And as I say, there are now 4 elements for a bad faith failure to settle claim. You've got to show that the carrier, in rejecting the reasonable settlement demand, acted unreasonably. Thanks, Steve. All right, Hedayati is now this Pinto is the only case that came to the court on after a jury verdict. Hedayati is a summary judgment case, and all of the other bad faith cases are summary judgment cases. So, the court is considering these cases de novo, and so it's hard to know how much we can focus on these things. Cases tend to turn on facts. Hedayati is a bad faith case, also terrible facts. A woman, a medical student crossing the street, is hit in a crosswalk. I think she lost both of her legs. She was hospitalized on life support for a month or two. And of course, the insured driver's policy limits were $25,000. Within a few days after the adjuster interviewed its insured, the carrier knew the policy limits were gone. So 2 weeks after the incident, there's a demand made. So that, as you can see, the accident happened October 1st. Ultimately, the plaintiff's lawyer sends a written demand made during the week of Thanksgiving, demanding a response within 7 days, acceptance by UPS or FedEx that has to be received no later than Monday after Thanksgiving. And Auto Club blew it. I guess they got the letter on Monday and they didn't respond. And then on Tuesday, the adjuster, I guess, got back to the office and thought, oh no, what have I done? And so Auto Club called and asked for an extension to respond. And the plaintiff's lawyer said, no, I don't think so. The demand has expired. The offer has expired. So they then, next slide, please. That case actually proceeded to judgment, and they got a $26 million judgment against this insured, and an assignment of his bad faith rights, obviously in exchange for a covenant not to execute. Then Hediati's lawyers sued Auto Club on this assigned bad faith claim, and the trial court granted the Auto Club summary judgment motion on the basis that this Thanksgiving holiday made the deadline sort of unreasonable and arbitrary. That was kind of a gotcha. Regular viewers of these programs will know that Steve and I discuss this fairly often. You see a lot of cases where the Court of Appeal, and the trial courts as well, of course, express some kind of skepticism about gotcha tactics of bad faith plaintiffs' lawyers. And that seems like that was the approach of the trial court. The Court of Appeal reversed. They addressed both points, but the interesting thing about the Court of Appeals decision to me was that they focused on language in the complaint, in the bad faith action, that alleged that Auto Club had not communicated the settlement offer to the insured. And Auto Club's papers didn't address that allegation at all. And so the Court of Appeal said, well, that's a triable issue of fact, whether the failure to communicate the settlement offer to the insured was reasonable or not, whether in fact they did communicate it, but they didn't address that. And so they didn't even shift the burden onto the defendant, the Court of Appeals, as the Court of Appeals saw it, to show that it had a cause of action. They also did say that the reasonable trier of fact could find that plaintiff's counsel had a good reason to draw a line in the sand. And you see the accident happens on October 1st. It's tendered 2 weeks later. The carrier knows within days, hours, that the damages are way over $25,000, and they don't tender it. And what is more, Auto Club didn't even tender it when they realized that they had gone past the deadline. They just asked for more time. So you know, the Court of Appeal recognized all those things. So the key, I think, the lesson from Hediati is, if you're suing for bad faith on an assigned claim, include allegations about the failure to communicate the demand that your client made to the insured defendant, because those can help you, obviously.
Now I finally understand why you chose the slide that you did for this case.
Oh yeah, failure to communicate. Yeah, that's Cool Hand Luke, one of my favorite movies and one of my favorite scenes.
Okay, we have 3 other bad faith cases, Mike. Is there any one that you think is more important than the others to talk about?
Actually, Hediati, well, there's a deer. Here's Planet Bingo. Planet Bingo is probably not all that important. You can read it yourself. You see the site. This one for sure, McIsaac, is not as important. A deer is probably well, Antonopoulos is a lapse policy case. This is failure to pay the premium. That's why Picard is slapping his forehead. And there are some interesting facts to it. Let's move through this one quickly. The issue was, of course, the fire loss happened after the policy, during the period of the policy lapse, but then Antonopoulos paid the past due premium, and the carrier reinstated the policy. And the question was, does the reinstatement cover the lapse period or not? The court analyzed issues of waiver pretty closely, and if you read the case, you'll see that Mid-Century Insurance did some kind of odd things. They added the 9 days to the end of the policy, but they didn't clearly say in the reinstatement paperwork that there was no coverage during the lapse. And the question was that intentional or not? The trial court, surprisingly, the trial court ruled for the Antonopouloses, denied the summary judgment motion of the carrier, and granted the insured summary judgment motion. On appeal, the Court of Appeals sort of made it into a tie. They reversed the granting of the Antonopoulos's MSJ, but affirmed the denial of the carrier's MSJ. So that means that Antonopoulos will have to go back and prove to some degree that the carrier did intend to reinstate the policy without lapse. So we can move on to the next one. A deer.
Okay.
I think, is a deer.
Let me go. Let's do this, Mike. Let's go back to the third-party cases and let me talk about the need case, and then you can talk about a deer, and then we can start wrapping up. Yeah, because there were two third-party cases, third-party insurance coverage cases that were in our outline for last year. They both have to do with the payment, the duty to defend, and the payment of attorney's fees. Need management has to do with CUMIS fees. In that case, the plaintiff sought a declaration that they had been entitled to CUMIS fees or independent counsel fees in connection with an underlying bodily injury case. And what had happened is the insurance company had reserved its right not to pay any judgment in excess of the policy limits and not to pay any punitive damages. The insureds contended that those reservations, as well as instances of appointed counsel allegedly failing to properly defend them, gave rise to a right to independent counsel under Civil Code Section 2860. And as a reminder, Civil Code 2860 applies when the outcome of a coverage issue can be controlled by the panel counsel that's appointed by the insurance company. In those cases, the insured has a right to select their own counsel to be paid for by the insurance company. And the plaintiffs in this case, frankly, their allegations were pretty clearly outside 2860. In addition to what I just mentioned, they were claiming that the lawyers, panel counsel, were hostile to them because they believed that they lacked credibility. The court sustained a demur without leave to amend to the complaint, finding that the reservations about punitive damages in the policy limits are actually specifically exempted from the independent counsel requirement by 2860B. And that the failure and that this allegation that the appointed counsel were mean to them or didn't properly defend them is not the type of conflict that gives rise to a 2860 right. So that was a fairly straightforward application of 2860. It's a good reminder of what 2860 is all about. Really, the question I had in my mind when I read it is, why did the Court of Appeal even bother publishing this case? The answer is that it was really a civil procedure question, not so much a 2860 question, because the court noted that, as a matter of pleading of the appropriateness of declaratory relief, that they had properly pled that there was a controversy between the parties, and that normally that's enough to state a claim for declaratory relief. But they found that in this case, that because the facts as pled resolved the issue as a matter of law, that there was no harm in the Court of Appeal making the determination, which sparked a concurring opinion, which I think, found that justice felt that the Court of Appeal, that the majority was kind of taking an overly formalistic approach to what should happen on demur, and that in his view, I can't remember if it was he or a she, that they felt that, hey, if the undisputed facts in the complaint only allow for one outcome, it's okay to resolve that on demur. So now let's go to the other attorney's fees case that Mike mentioned, Adair International. So
Adair is interesting. There's a section of the insurance code that prohibits insurance to indemnify or defend actions brought by the Attorney General for unfair competition or false advertising. So Adair is the company that operates the Curacao stores in California, Nevada, and Arizona. And the California Attorney General sued Adair for violations of the unfair competition law and false advertising law, alleging that they were predatorily targeting their predominantly Latino customer base. So Adair tendered the case to Star Indemnity and Liability, and initially Star accepted tender under a reservation of rights, and then the Attorney General notified Star that they would be violating this section 533.5 of the insurance code, and Star withdrew their coverage and reserved reimbursement rights. Adair sued the carrier, and the trial court Now, this is a federal court case. So the district court granted Starr's motion for summary judgment and then went on to award Starr $2 million in reimbursement. So a case of, be careful what you wish for. Adair on appeal argued that Section 533.5 was a violation of the due process rights of policyholders under the 5th and 14th Amendments because it interfered with the ability to hire and pay chosen counsel. Now, obviously, we are familiar with the 6th Amendment right to counsel, and part of the opinion of the Ninth Circuit, which affirmed the granting of the summary judgment motion, was spent on distinguishing the 6th Amendment right to counsel, which is much more robust and broader in a criminal setting than the 5th or 14th Amendment rights to counsel. So it says that the 5th Amendment due process right to retain counsel in civil cases appears to apply only in extreme scenarios where the government substantially interferes with a party's ability to communicate with his or her lawyer, or actively prevents a party who is willing and able to obtain counsel from doing so, but it doesn't include a right to use insurance proceeds to pay for legal fees. Indeed, Adair hired a lawyer to pursue this case. The bottom line, as the Court of Appeals in federal court saw it, was that California's law only makes it harder, but not necessarily impossible, for a civil litigant to retain the counsel of their choice. And the 5th and 14th Amendment rights to counsel would require basically that they would have to render it virtually impossible. It raises an interesting question, though, of course, because as you can see, that California has stacked the deck. This is how the Ninth Circuit termed it, against defendants by invoking state power to deny insurance coverage already paid for without having proved its complaint, right? So this is a situation where there is a penalty immediately against the UCL or FAL defendant of losing its insurance coverage without proving a single fact. But the 5th and 14th Amendments don't protect a policyholder against that, according to the Ninth Circuit.
Excellent. Okay. Mike, we got in a question about Pinto. So before I move on to the last couple cases or points, I want to go back to that. And it has to do with the 3 elements that are in Casey. And the question was, why isn't the plaintiff's duty to prove the conduct was unreasonable subsumed in the 2nd element, that the carrier failed to accept a reasonable settlement demand within policy limits?
Because that 2nd element focuses on the reasonableness of the offer, not on the reasonableness of the carrier's conduct. At least that's how it was presented in Pinto. So the Pinto court adds this 4th element that says that the denial or the rejection of the reasonable settlement offer was itself unreasonable. Or I guess you could point to some other unreasonable conduct, but you've got to find that too. Yeah. And I agree with the person who asked why the court didn't vacate and order a new trial as opposed to entering judgment for the defendant. I think that might have been a more judicious response, but I'm not sitting on the Court of Appeals, so.
Okay, good. So I think what I'll do with the 5 minutes that we have left is just do a little bit on coming attractions. What is it that is on the docket for the California Supreme Court this year? There are 2 insurance cases, one of which I would say is going to have a fairly significant effect, and the other of which seems to be a somewhat more niche question, but both of them came from the Ninth Circuit asking for guidance from the California Supreme Court, and it appears that the California Supreme Court is generally pretty receptive to those requests when they come from the Ninth Circuit. This one, the Yahoo versus National Union fire insurance case, has been pending for quite some time, and the case has been fully briefed. I believe that notification has gone out that it'll be set for oral argument soon, so we can expect a decision in the relatively near future. And this has to do with whether there is coverage, or at least a defense, for defendants who are sued for violations of the Telephone Consumer Protection Act. And that we have the question up there, and it's whether personal injury, which includes injury arising out of oral or written publication of material that violates a person's right of privacy, whether that triggers the insurer's duty to defend against the TCPA claim. And TCPA claims are based on unsolicited text message advertisements. The kind of interesting question there is, under California law, the right to privacy includes a couple different types of rights. One is the right to be free from unwanted intrusions, and there's sort of a separate right under that rubric, which is the right to keep personal information confidential. And the TCPA claim really implicates only the first right. There's no confidential information that is being released. It's just that you, on the receiving end of the unwanted text message, are having your virtual space invaded by this unwanted text message. And apparently courts around the country have been divided on whether this is something that should be covered under personal and advertising injury. And there is one California Court of Appeal case out there from several years ago, 2010, that had found that those kinds of claims are not covered, but the Ninth Circuit stated that it can't confidently say that it necessarily thinks that the California Supreme Court would agree with that old case. It's called State Farm versus JT's Frames. And so it has asked for the court, for the Supreme Court to get involved, and it is, and we should know the answer to that soon. The last case that's not quite as far along, I don't think, in terms of when we'll get a decision, is this Allied Premier Insurance case. And it has to do with commercial auto policies that are issued to and purchased by truck drivers. And there's a provision under the Motor Carriers of Property Permit Act, which is a California statute, that requires the insurer to file a cancellation or a notice of cancellation with the Department of Motor Vehicles when a policy has expired. And there's a relatively old California Supreme Court case that's referenced in the question presented, and this is taken from the Supreme Court's framing of the question, that was decided under a prior version of the law that said that until that cancellation is filed, the policy remains in effect, whether it's been canceled or expired from the perspective of the insured and the carrier or not. And there's arguments on both sides as to whether that prior ruling should apply under the new law, and the Supreme Court has agreed to consider that as well. So Mike, do you have any sort of last words here before you have to go to trial and as we finish up?
Well, I think it's interesting. There have been a lot of bad faith cases and even attempts to adopt or adapt bad faith to home insurance contracts. And I think that we'll probably see more bad faith claims coming up, maybe as a result of the pandemic, not pandemic related, but those are becoming when we looked at all of our cases, we had something like 15 or 16 cases, and you saw how many of them were bad faith. A lot of those cases are summary judgment, though, so you don't really know how they're going to end up. But the main thing I'd like to say is thank you and thank our audience for listening. It's been a pleasure.
Thanks, everyone. Have a great day.